So in this age of COVID-19, we're seeing a lot more temporary layoffs, and we don't know if these layoffs are going to be permanent or if they are in fact temporary. But what's important for employees is that generally for non-unionized employees, temporary layoffs aren't usually allowed. So that means that if someone is temporarily laid off, they have to go through a couple of steps. First, they have to decide, do they want to keep working for their employer? If they don't, there's a possibility that they can claim constructive dismissal. They can say that they've been actually terminated by being temporarily laid off. A lot of employees aren't going to want to claim constructive dismissal. They're going to want to stick it out. Maybe they'll have a job left for them at the end of the day. So if that's the case, they should be applying for employment insurance. They should be getting that employment insurance. And then when or if they're called back to work, then they can potentially ask for the difference between the employment insurance and how much they were getting before, if it's not in their contract that they're actually allowed to be temporarily laid off. The Court of Appeal of Ontario has made it very clear that employers are not allowed to lay off employees unless they have an explicit contract saying that they can. So if it's in the initial employment agreement, and the vast majority do not have temporary layoff provisions in employment agreements. So in this age of COVID-19, we see that the issue is with more and more layoffs happening, be they temporary or permanent layoffs, that these are possibly not allowed, although it is a novel situation. Therefore, what the employee might be entitled to, if they choose to stay in their job and they get recalled to their job, what they might be entitled to is the difference between what they got in employment insurance and what they were getting before. In the alternative, if they are laid off for a prolonged period of time, somewhere between 13 and 35 weeks, depending on if they're being provided benefits during that time, they would be found to be actually terminated, and then they'd be entitled to reasonable common law notice based on that termination, which would be somewhere between 3 to 5 weeks per year of service, usually with a minimum of 3 months for an employee who's terminated, unless their contract states otherwise. It's important to note that in Ontario, even though a lot of companies might be suffering from the COVID-19 pandemic, that a company not having enough money isn't a good reason for them to let an employee go. Those employees are still owed reasonable common law notice, even if the company is suffering financially. This only changes if there's a bankruptcy or other issues. It's important to check with an employment lawyer about if you're let go, if you might be owed compensation, either for severance pay, termination pay, or based on past work such as vacation pay or overtime pay. It is important for the employers to work with employees to attempt to minimize that risk, and that's going to result in a better workplace overall. It's important for people to work together in this very difficult time, and hopefully an extremely Canadian way, to be able to continue to allow operations while also minimizing the risk to employees, staff, customers, and others from this pandemic.